Great. Thank you very much for joining us today to assist the committee with our work. Does anyone wish to make an opening statement?
No, thank you.
No, thank you.
Great. Okay. I'll jump straight into questions then, and then I'll share the call with my other colleagues who are joining us via video conference. In your submission, which was lodged in December last year, this is the Attorney-General's Department, although it may relate to the AFP as well, you noted that at that time only one individual had been charged under the foreign interference provisions that were enacted in 2018. There's now been a second person who's been charged since then. Neither have been convicted, and both matters are before the courts, so I won't ask you too much specificity about these cases. But am I right in understanding that these laws have never been used to target anyone who's been guilty of foreign interference through a social media platform as the primary means of that activity?
I might defer to my colleagues on that, given they're sort of doing the investigatory work.
So just to clarify, Senator, are you saying was there involvement in a social media platform as part of the allegation?
That's kind of a separate question. My question was, has anyone been charged under the EFI legislation for conducting foreign interference via a social media platform?
Thank you. No.
No. To your other point, it's my understanding, and you can correct me if I'm wrong, that social media platforms were a vector for communicating with the individuals involved in both of these cases, but neither of them have been charged with conducting foreign interference via a social media platform. Is that a fair summary?
That's correct, Senator.
Yeah, great. What are the main challenges in charging someone with foreign interference through a social media platform? What are the main obstacles to doing so?
Happy for me? Yep. Okay, I'll take the lead on that one, Senator. So in terms, it depends on the underlying offence under consideration, but if I can speak more broadly, our primary consideration is the involvement of a foreign actor and to whether an individual is working in collaboration with a foreign actor or as a proxy. So that's a key requirement. And then obviously we have to look at the other elements of the offence, whereas it goes to government processes, political processes, political rights or democratic rights being exercised. Whether it's an intelligence objective of the foreign principle is what the activity is related to, or it's adverse against the national security of Australia. And then we then consider whether the conduct involved an element of covert and deception, or whether there was a threat of serious harm or the demand with menace. So when you look at, that's the collective of what needs to be proven. So where social media is a vector and the evidence may be offshore, for example, that could impact several elements of the offences as outlined in the legislation.
So, because I ask these questions because I mean it's clear that foreign interference is a major problem in Australia. The ASIO's assessment is it's now our principal security concern, and it's clear that a lot of it is taking place via social media, but no one has been charged with those offences. So each of those elements that you stepped out, proving that it is activity conducted on behalf of or for a foreign principal, how challenging is establishing that in your investigations?
It's a challenge meeting those requirements, but obviously the involvement of a foreign principal makes the offence of foreign interference. So, I mean, technology does prove challenges. There are geographical elements of the offences available, but still then there are practicalities to obtaining evidence with respect to those incidents or offences.
Are the primary obstacles the cooperation of social media platforms? Are they technical in nature, making those assessments difficult? What are the or that the evidence is located offshore? What are the primary obstacles?
Noting that we haven't had a matter that's before the court involving social media being the means by which foreign interference is been carried out, so I'll take it as a hypothetical, Senator. In those circumstances, the level of cooperation with a social media platform or provider could potentially impact the ability to obtain information. Obviously, when it comes to obtaining evidence offshore, we have to go through in some cases police-to-police cooperation, use relationships that we may have with social media providers to obtain that information, but ultimately we will end up requiring that evidence under the Foreign Evidence Act, and then utilising the mutual assistance in criminal matters processes to bring that in. So it's really the prospect of cooperation, I guess, is a factor.
And noting as the caveat that the two cases we currently have before the courts are not about interference through social media, they nonetheless had an element of social media applications involved. It's my understanding from the documents presented to the court in the Sunny Duong case that it's alleged that he communicated with the Chinese intelligence agency via WeChat. In that case, has either WeChat or Chinese police been cooperative in obtaining evidence necessary for that case?
Given that it's before the court, Senator, I won't mention those cases. We've got legal protections as well in the proceedings that have already occurred, and also legal protections that are planned for the next court phase. So I won't answer in an open forum, Senator.
Yeah, look, I do understand your the sensitivity about that and your reluctance to do so, which is reasonable. It just would be a helpful case study to know, and perhaps it's something we'll just have to explore after the case is concluded, about whether or not that cooperation has been forthcoming from WeChat or other platforms, and whether it's been forthcoming from Chinese police or security services. Turning to the other matter that a gentleman more recently charged in Sydney, it's my understanding it's alleged that there was communication on the LinkedIn platform, that he was initially approached on the LinkedIn platform when, as part of the alleged cultivation recruitment program. Are you able to talk about LinkedIn's cooperation in that case?
I'm not aware of what requests we may have made with LinkedIn on that occasion. I know LinkedIn was referenced in court on the court of first appearance, which is why the only reason why I'm mentioning it, Senator.
Yeah.
But I'm not aware of any challenges on that front.
Okay. I appreciate also that if these are genuine cases of foreign interference that you identify, it's very likely that the people responsible are doing so from offshore, which presents some challenges with us charging them in Australia. But our American friends in the Department of Justice and the FBI have released a number of indictments in recent months and years that are primarily targeting people who are offshore. And having met with them previously and discussed this with them, I understand their motivation to be in part to discourage this activity, to put a cost on this activity, because even if you are never going to enter onto US soil, having an indictment in your name is a serious disincentive to this conduct. And secondly, also the educative function that it plays for Australians when we're trying to guard against foreign interference risks ourselves, that indictments are often very detailed and provide flavour to the public conversation about these risks. Has the department or the AFP considered the value of us launching prosecutions or we don't have quite the same system as the US, but indictments that effectively have fulfilled those two objectives?
Do you want to go first? Yes?
I mean, we would see that as an operational decision.
Sure.
So you're right about the legal systems. That's not something that that quite translates to how we would work that in Australia. The closest thing to it, though, Senator, would be we would have a first instance arrest warrant potentially lodged for individuals who are offshore, and should they come to notice of a jurisdiction with which we have mutual cooperation arrangements, we would then seek to exercise the arrest warrant in those cases. But that the open indictments in the manner you characterise just doesn't work in our system. I do understand that they do have a different way of managing it. Nonetheless, I think an arrest warrant that was issued for an individual who we suspected was involved in commissioning foreign interference offence in Australia would have the similar value to those US indictments, and then it would be a discouragement, a disincentive from engaging in that conduct, and it would serve an educative purpose. So has AFP considered the merits of doing that? We have, yes.
Yeah. And are there any, without going into the specific details, are there any cases that would meet the criteria for that kind of action?
Not strictly speaking on foreign interference, but related offences.
Okay.
But again, I'm not going to mention them. So.
Sure, no, I understand. Do you cooperate with ASD in trying to identify sources of foreign interference, trying to attribute foreign interference to a particular actor?
I won't go into our exact cooperation arrangement with ASD, but they are a member of the Counter Foreign Interference Task Force, which of course we're a member of the Counter Foreign Interference Task Force.
We've had some witnesses before the committee who've spoken about the impact on them of what they see as transnational repression from the Chinese Australian diaspora community, the Iranian diaspora community, the Ukrainian community, Tibetans, others have brought evidence forward that they believe they're being targeted and harassed online for their activism or their political views or their research or their work. And some of them reported that they've made contact with the National Security Hotline to refer these matters. Not all of them have been satisfied with that experience. They sometimes say they don't get any feedback after lodging those reports, and that there's no evidence then that anything changes. What can you say in a public forum to give them confidence that when those reports are brought forward that they're dealt with and treated seriously, and that within the powers that you have are actioned?
Yes, thank you. So foreign interference community is a significant issue and one that we prioritise in the task force, but also specifically in the Australian Federal Police. As part of our initiatives, we have issued a fact sheet on foreign interference in community, made that available not only publicly on our website in English, but also currently in 36 languages. So we recognise that there are communities who feel the impact of foreign interference being directed towards them. We've also used those fact sheets as part of our community liaison strategy and meet with vulnerable communities and communities who have raised concerns about being targeted by foreign entities. That is also characterised in terms of potentially in person, but of course online as well. And in that fact sheet, we provide advice on how to report it. And I understand the comment around feedback on reporting of National Security Hotline, and it is not something that we will do in terms of a callback on National Security Hotline, or even acknowledge publicly whether a person has actually contacted the National Security Hotline. Due to the sensitivity of the situation. However, what I can say to the public, and have done so through community meetings, is that reporting to the National Security Hotline is the best means to report if you feel you're being subjected to foreign interference. If you're feeling that you're in direct physical harm, though, you should always call 000 in the first instance. But outside of those circumstances, Senator, to contact the National Security Hotline. The value to that is that it goes to multiple agencies and agencies that need to know. In terms of our response, we look at matters from a harm basis. So a high harm report is something that is prioritised. Now, high harm in terms of community interference or foreign interference in community or transnational repression, depends on which stream you're listening to, is really where there are actual threats or demands with menace that involves the potential for serious physical harm being directed at a person or a community. So that's the priority areas that we look at. But obviously there's a range of allegations that come in. And going back to my earlier point, Senator, is one of our first tasks really, outside of triaging it for harm, is then looking whether there's foreign principal involvement.
And just without going into too much detail, how do you make that assessment? Is a foreign principal involved here? Someone reports to you, I'm being harassed on Twitter by these coordinated inauthentic accounts. I'm an activist and it clearly aimed at silencing me. They report it to you. How do you decide, well, this is just nationalist activist acting spontaneously, or this is a nation state which is behind this?
Well, obviously you look at on the face of the reporting received and whether there's elements there that you can corroborate. We engage in traditional investigation techniques to verify what is actually occurring. And then, of course, as a task force, we work to see whether there's broader elements that are taken into consideration with the reporting. The biggest challenge, as I pointed out earlier, was that foreign principal element, and I know that there is a quantum of reporting where people who are feeling intimidated or feeling that they're subject to foreign interference, and in our case, if we are unable to establish a foreign actor involvement, that does limit our ability to respond under the foreign interference legislation.
The legislation obviously sets quite a high bar to prove a foreign interference offence, and I think that the Parliament decided to do that with good reason. They wouldn't want this to be misused. But are there any challenges in the way that the offences are crafted in the legislation that make it more difficult for the AFP to successfully prosecute a case? I mean, we'll know more when these two matters before the courts are resolved, but speaking generally about foreign interference, especially through social media, are there any legislative barriers that exist?
Nothing that springs to mind. Obviously, I think once the court does consider the legislation, we'll be in a better position, as you said, Senator. I know we have regular discussions on this issue, looking for any aspects that may need reform, and of course the legislation itself, and I may hand over here, is that is subject to a review function.
Yes, and I might just add, we continue to engage with the task force, including the AFP, on how the offences are working in practice, so doing some of that consideration ourselves, but there's also an independent National Security Legislation Monitor report that we'd expect review to begin end of this year, early next, I think, that will enable kind of thorough review as well.
Yes, I've discussed that with the Insulum in estimates and elsewhere, and the current Insulum doesn't believe he'll be able to commence it, or certainly not even certainly not conclude it by the end of his term. So it will fall to a new Insulum to complete that work. So it might not be for some time until that's done. As you say, it won't even commence till the end of this year, and Insulum reviews can be quite lengthy and exacting, as they should be. So perhaps if you could, both the AFP and AGD, take on notice and come back to me. Certainly you won't have the benefit of the court findings before we have to conclude our work, but just any preliminary or initial thinking you're having about the legislation, any obstacles that exist in it to successful prosecutions.
I mean, I could answer that now because it is something we discuss. So I think no significant issues that have been identified at this stage, but we continue, and had a task force steering committee meeting where we discussed the work we're doing together to look at the legislation. I think the two cases will be quite informative, but certainly we've made it clear as a department that were there sort of any real operational impediments to be identified as part of the task force work that required urgent action, we will obviously be very much prepared to provide advice to our Minister and the Government on any earlier amendments should any be identified. Okay,
great, thank you. I'm pleased to hear that. Turning to the department now in relation to the Foreign Influence Transparency Scheme, has any actor registered that they are conducting influence campaigns through social media on behalf of a foreign government?
So, Senator, we've got about half a dozen registrants on the scheme that have registered quite expressly in relation to social media activities, whether they're on behalf of a foreign government-related entity, a foreign political organisation. I'd have to take on notice for that breakdown. The scheme, the legislative framework itself doesn't require registrations to expressly denote that they are in relation to social media activities. So there are I think several dozen more registrants who are engaging in sort of a range of communications activities that may well include social media activity as well as public speeches or traditional media activities. Beyond that as well.
What can you tell me about the ones that have kind of proactively identified a social media component? You said there's half a dozen. What can you tell me about them?
So there's sort of a range of those entities. So I think, let's see if I've got some here. So they sort of range from sort of political activist groups through foreign government-related entities which are undertaking sort of major investments in Australia and undertaking social media activities in support of, decisions around sort of major investments. As well as groups that are focused on inter-country cooperation and the like. So it's a range of different entities and organisations.
Yeah, perhaps on notice you could provide some more detail about each of those entities and the activities that they've registered. And I anticipate that much of it is probably completely harmless and anodyne, and it's just good that it's transparent through that process. But how much of this sort of activity do you think that FITS is currently capturing compared to what is actually taking place?
Sure. So I think at that point I'd probably just pull back slightly, Chair, and sort of that broader communications activity definition. Certainly, as part of our work looking at particular cases, we absolutely do look at social media activities along with all other public communications activities that particular entities are undertaking. We look at that across, sort of traditional Western social media platforms. We look at WeChat as well, and other international social media platforms targeting Australians. To look at whether those individual actors are undertaking influence activities on behalf of a foreign principal. So I think we do have a number of registrants who are engaging in communications activities broadly described on behalf of foreign principals that are covered by the scheme. But as I say, the Act does not require them to expressly denote whether their activities are on social media or not.
But would you think it's fair to say that we're capturing a minority of it, a majority of it, all of it? What would your assessment be?
Look, Senator, I probably wouldn't try to characterise it in those terms. I think, through the Parliamentary Joint Committee on Intelligence and Security inquiry, we've had a number of conversations around some of the opportunities to improve the operation of the scheme. And I think, as we've also said in that context, we absolutely do take a risk-based approach to enforcement. As you mentioned, there are a number of influence activities that people undertake on behalf of foreign principals that are relatively anodyne. We absolutely do encourage those to be registered. When they come to our attention, we will engage to secure registration. But obviously, from a compliance and enforcement point of view, where those activities are relatively transparent and relatively low risk in terms of the degree of influence they may have on an Australian government decision-making process, that isn't where we will devote our time and energy. So in that sense, it wouldn't surprise me. I would firmly acknowledge that there be activities that aren't registered sort of in that category. We do devote our time and energy to sort of the higher risk categories where there is a lack of transparency or potential to actually substantively influence a government decision-making process.
Yeah, and your point about the Intelligence Committee inquiry is a good one. It's our fault, not yours, that we haven't concluded our work on that, and we do. And I hope we're able to conclude that soon and make some recommendations for changes to the legislation, because I think that some of the solutions the department has put forward are very constructive and will help address some of these issues. But yesterday we had many of the social media platforms appear. All of them, curiously or perhaps not curiously, other than TikTok, said that they'd identified influence operations trying to influence Australians and that they had removed them. But they have a very high bar for removing that. They wouldn't be looking at a kind of a community organisation in Australia running an influence campaign which is ostensibly transparent, although it doesn't disclose the foreign government backing that that group might have. They're really looking at highly sophisticated, coordinated and authentic accounts that are, breaching their platform rules in that way. So if all of them are identifying them, and in some cases they said hundreds of them, in Meta's cases that they've found and dismantled hundreds of them, not all of them directed at Australia, but some of them directed at Australia. It seems to me like there probably is a large number that are not being captured currently by the Act. Would you think that's a fair observation based on that evidence?
I think that is certainly a possibility. We do track the transparency reporting from those social media platforms to look at that coordinated and authentic behaviour and where it may constitute an influence activity within the framework of the Act that is directed at Australia, in Australia being one of the criteria. Some of that activity, of course, will cross the line into foreign interference activity, quite distinct from foreign influence activity. In those contexts, we, of course, engage closely with our partners in the Foreign Interference Task Force, Foreign Interference Coordinator's Office and the like. And I think in that context, that is sort of the appropriate area for any government response to be coordinated or led by. So there will be some of those cases where we may well sort of have visibility of it. I think as Meta did say, some activities directed at Australia. But whether or not that is something that sort of fits is the appropriate response to, as opposed to another government response or engagement with the platforms is a separate question, I think.
Yeah, fair enough. Moving on to one other topic, and then I'll share the call with the Deputy Chair, Senator Walsh. We've discussed in the estimates context, I think it was you, Ms Chidgey, about the PSPF direction on the 4th of April in relation to TikTok, which only applied to government employees and not contractors. You might have seen reporting in the Financial Review yesterday by Max Mason that after I wrote to some of the major consulting firms to ask them what their policies were about TikTok, some of them have decided to ban TikTok, at least on the devices of employees who are engaged in government work. The government's not yet issued a direction or guidance, as far as I'm aware, to government contractors. Is the government considering doing so?
Senator, the Protective Security Policy Framework operates under the Public Governance Performance and Accountability Act, so it applies to non-corporate Commonwealth entities, doesn't directly regulate any other entities, either corporate bodies within the Commonwealth or outside. So it's policy 6 of the PSPF, though, requires non-corporate Commonwealth entities to be accountable for security risks arising from any contractual arrangements they have, and to then place security requirements on those they contract. As you can imagine, there's a range of contractual requirements, some of which, depending on the service, it might be irrelevant. That, you know, for a gardening service, it doesn't really matter if those people have TikTok on their personal devices. But the requirements under the PSPF would mean that for any entity that contracts and, for example, is providing sensitive government information to a contractual provider, they would look at those risks. And if TikTok created a risk to that information, for example, which may or may not be the case, the PSPF clearly requires that there are security requirements that government needs to protect. Its functions have to be applied through contractual arrangements.
The government has banned it, though, from all departments and agencies, with a limited exemption to be granted if there's a necessary purpose for it to be used, and that includes highly sensitive government agencies and less sensitive government agencies. So there's obviously recognition that this is a risk across the board, which the government doesn't want to tolerate. So really, it shouldn't be any government contractor who's working for or with a government department who should have these devices on their phone. I mean, I take your point about a gardener. It's probably not the greatest national security risk, but pretty much anyone else dealing with confidential or classified information certainly shouldn't have it on their device. Whether the hat they're wearing is Accenture or the hat they're wearing is ASD or AGD or Home Affairs or whatever.
So the PSPF has quite extensive requirements. Policy 6 is security governance for contracted goods and service providers. And it's through that mechanism that entities that contract need to consider those security risks. If that involved TikTok on devices of those they were working with, then entities need to consider that. And the I think fundamentally, though, the Protective Security Policy Framework can only regulate non-corporate Commonwealth entities, and therefore the way we have it, sort of making sure that security risks through supply chains and contractual arrangements is through the policy, which very much looks at all of, it requires risk assessments for any security risks in procurement, protective security terms and conditions in contracts, management on an ongoing basis of protective security under contracts, and has quite extensive requirements and guidance for entities when they're entering into those contractual arrangements.
Do you know how many departments and agencies have used the contracting mechanism to put these requirements in place for their contractors?
No, Senator.
Is there anyone in government who would have central visibility of that? Is it within AGDB or another department?
So we require all non-corporate Commonwealth entities to report on their implementation of all the PSPF requirements. As part of that, and we're in the reporting period for the last financial year at the moment, so we'll have the first reporting on the application of the TikTok direction coming through in coming months. That won't necessarily pick up all the detail of every, as you can imagine, we don't ask for people to explain every contractual clause that they've got in all their contracts, but they need to indicate that they've applied the requirements of Policy 6.
How will government know, though, that its policy intent has been reflected in practice if there isn't, if it isn't being reported and there isn't some central repository of that information?
So entities will need to report on compliance with that direction. They also will need to report on how they've given effect to security governance for contractual arrangements at some level, but that doesn't necessarily mean, as you can imagine, we don't want to know every detail of every contractual arrangement all of them have, but it is an obligation under the Public Governance Performance and Accountability Act that every entity applies the PSPF.
I'm just thinking government's a big beast. There are a lot of departments and agencies that have varying levels of sophistication in terms of their security knowledge and particularly their cybersecurity knowledge. It would be of concern, I'm sure, to the government if they knew that there was a department and agency that hadn't acquitted its responsibilities under the PGPA to reflect this directive. So how will we know this has been done to our satisfaction? How will we be able to have confidence in that?
So agencies need to report, as I've said, on their implementation of the PSPF, and that is how we know if, and it's a maturity level reporting, so but they'll report on according to those sort of requirements and guidance at the extent to which they've implemented those requirements to us. And we do a lot of ongoing...
I'm just conscious of the time. I want to hand over to Senator Walsh. Will that be publicly reported at any point?
Not on an individual agency basis. We do annual reporting at a whole of Commonwealth level on compliance across the PSPF policies. And we just continue to work along with ASD on cybersecurity requirements with agencies, and obviously on the TikTok direction did a lot of outreach to make every entity aware of their obligations. Yeah.
Could I ask that you reflect on notice on what you can provide to the committee of that reporting, which is coming back to you at the moment? As you say, it's...
We won't be able to give you anything. The reporting period really just started and it doesn't conclude for another couple of months. Right. And then we'll prepare the public report that will be available later in the year.
Okay, all right. Well, I'll look out for that public report. The thing I'd leave you with is that in my discussions with these consulting firms, they said they hadn't been given any clarity about what they should do with TikTok from any of the government departments who they contract for, and that they have made this decision on a precautionary or proactive basis because they've observed that the government has put this requirement on government departments and agencies, but they didn't get any clarity from government about that, and I think that is a gap. I think they would have much rather to have some clarity about what they should or shouldn't do. Thank you.